Good morning, Judge Sutherland.
Good morning, Chief Justice. Commissioners, good morning.
How are you, sir?
I'm excellent, thank you.
Thank you. You look comfortable, so I won't spend much time trying to settle you down. You started your career as a prosecutor, am I right?
That's correct.
I can barely hear the candidate, Chief Justice.
Judge, if you could please bring your mic closer. President Mahaya is struggling to hear you.
Yes, forgive me. My answer
Thank
was
you.
I did start as a prosecutor.
And then, yes. Now, before we come to your judgeship, for how many years were you junior counsel, and for how many years senior counsel?
I was a junior for 16 years and a silk for 16 years before I took a permanent appointment.
Sorry, Chief Justice, he's fading. I don't know. He sounds very far.
Right, is that a little better?
I can't hear you.
I'll keep it very close.
For 16 years and senior for 16
That's right.
years. All right. For how many years have you been a judge?
This will be my 9th year. I took a permanent appointment in January 2012.
And for how long have you acted as Deputy Judge President?
On and off now for getting on for 2 years. I've had 3 spells acting. The first was in August of 2019, and then later on in 2020, and again now in 2021. So this is my 3rd spell as acting AGJP.
Thank you. I'm going to let the JP continue. I just want to take up the names of colleagues who would want to put questions to you. I made an error for which I apologize most profusely, colleagues. Please bear with me. I should have welcomed Judge President Leo, who's representing the Judges President, because Judge President Mlambo, who was relieving her, now has to be JP for the purpose of Gauteng. And I should also have welcomed the Honorable MEC Lusufi, who is representing the Premier. I apologize for the lapse. I can assure you, it has nothing to do with the consumables over the weekend. May I have the names of colleagues who would want to put questions to the judge, please?
Lamola, Magwanisha,
Wima, Bofu,
Tepe,
Nyambi,
Schlimmer,
Dodovu,
Bonod,
Thank you. JP, over to you.
Thank you very much, Chief Justice. Judge Sutherland, you are applying for a leadership position in the Johannesburg High Court. You've sketched in your questionnaire the leadership role you've played. I just wanted to tap onto that. Are there matters that you, of a leadership nature, that you dealt with even when you were not acting as DJP?
That is correct, JP.
Could you tell the Commission of that, please?
I've been the lead in rolling out case management since 2014. You'll recall that when the Chief Justice announced that the judiciary should shift to a more judge-centered process, the divisions were all invited to pilot a case management model. And in 2014, the then Deputy Judge President Mojapelo asked me to frame a model which would work in Johannesburg. So I did that. It went to a committee. We workshopped that and we implemented that. And that model, with adaptations as we went along, was in operation until the middle of 2019. And the relevance of 2019 is that is when Rule 37A, as it is presently now, in force, came into force. The task team which did the legwork on preparing Rule 37A drafts was one chaired by DJP Traverso. I was one of the members of that national task team that did the legwork on that. So when Rule 37A was introduced, effective 1 July, the DJP asked me to prepare a model to align the practice in Gauteng with what Rule 37A provided for. Bearing in mind that that rule anticipates that the judge's president will have to tailor to the circumstances prevalent in their particular divisions. So I devised a directive which was then put into force, and it had certain novel features which have been important for the rollout of case management from that time.
Let me stop you there. The case management initiative that the Chief Justice introduced, even before he was Chief Justice, after 2010, became more relevant when the RAF phenomenon, that's what I'll call it, reared its head. There was a directive that was issued that was very unpopular. That was issued, I think it's called the 2 July or 2 August directive. Did you play any role in that?
I did indeed.
Were you acting at the time?
No, I wasn't. That was done simply as a member of a number of judges who was involved in advising the leadership.
Yeah.
But I had no formal role at that time. It was only
JP.
after,
Yes, Chief Justice.
I'm sorry, allow me, you and Judge Sutherland, to interrupt you. Judge, as you explained, for the benefit of those who might not be lawyers, commissioners who might not be lawyers, in a very simple way, you may wish to explain what the purpose of Rule 37A is so that they can follow your explanation. I'm sorry to interrupt you. I just thought it was necessary at this stage.
No, thank you, Chief Justice. The purpose of Rule 37A is to streamline procedure, particularly in regard to trials, but more broadly too, so that it becomes the norm that trials are not unnecessarily protracted, that preparation work on a trial is not unnecessarily protracted, and that matters do not settle at the doors of court and thereby jam up the available resources which are available for hearing trials. So the principal strategic objective is to get matters settled as soon as possible, and a judge intervenes in order to do that. If it can't be settled, it is to narrow the issues down to those issues which absolutely do need to go to trial or to a hearing, so that no unnecessary time is wasted in dealing with the dispatch of the work. In the course of that, one of the devices, which is compulsory for a judge to investigate, is whether or not mediation would indeed resolve the dispute rather than going the full litigation route. So those are the strategic objectives. The actual interaction is somewhat technical, but essentially what is required is for the judge who gives a certificate of readiness to do so only when settlement is no longer a reasonable prospect, where mediation has been considered and either tried or has not been successful, and where the issues have been narrowed down so that we can have a practical, sensible, streamlined trial or other hearing and use judicial resources as sparingly as possible.
Okay. Can I stop you there, Judge Sutherland? I think if commissioners want you to go further, they will ask you. Two more questions regarding case management. You coined the phrase phantom cases. I want you to explain what you meant by that in brief. And the other one is, have you played any role regarding the consolidation of the practice manuals of both divisions of the High Court in Gauteng?
Yes, thank you, JP. Let me contrast the way in which the trial roll was managed in July 2019 with the way it's managed now in 2021. The practice up until that time was to enroll 120 cases a day. That's 600 cases a week in the trial roll in Johannesburg. Although they were enrolled, everyone understood that 95% of them would never go to trial. That is why I called them phantoms. The practice was to, as a practitioner, get a trial date, have no intention of ever going to trial, and then settle at the 11th hour, thereby managing to garner up all the trial fees that one could. So there was an inherent abuse in the system. It also, of course, meant that the roll call ran 5 days a week for the whole day while people came in and out settling it. That was a complete waste of judicial resources. As a result of the model of case management we put into place, the position we have now, in contrast to there, is that the roll call takes 10 minutes. We have, through issuing certificates of readiness only to matters that are properly needing a trial, reduced from 120 to now a maximum of 16 matters a day. And we can manage that with our judicial resources. One of the great benefits, apart from the charade of having 100 matters on the roll every day, is that the lead time between applying for a date and getting a trial in 2019 was 1.5 years. The lead time now from applying for a date for a trial is 3 to 4 months. And that's due entirely to the new way in which we have shaped the management of the trial court.
Okay.
JP, I didn't hear, is it 16 or 60 matters now? 16 or 60?
What, 16?
Okay, thank you, sir. Continue, JP.
Thank you very much, Chief Justice. Just explain the need for the consolidation of the practice manuals of the two high courts, without explaining what's in there and the reason why it had to happen.
Yes. As you all know, the Gauteng division has 2 seats, both with a large volume of work, and in which a practice manual evolved in each seat, which was not identical to the other. That, of course, is an irritation to practitioners and also a difficulty for judges, because from time to time, judges in Johannesburg sit in Pretoria and vice versa. So there was a need to consolidate the practices of both seats into a single manual so that we can have uniformity throughout the division with the added efficiency and convenience that goes with that.
Yeah. And I think in all fairness, you did all that work and you were not acting as DJP. Simply it's
Yes.
you volunteered to do it and you did it.
I did, yes.
And JP is still sleeping on it instead of implementing it so far, isn't it? My last question to you is 3-pronged. You're a white man, you are 70 years old. No, 2-pronged, yeah. So white man, 70 years old. What is your view to you applying for this job with those 2 dynamics?
Well, let me deal with age first of all. The idea that you're washed up at 70 is a very old-fashioned idea. 70 is the new 50 in my book. I'm the life president of the club for promoting that idea. I think you'll find
Could you just stop at, I'm not sure. Chief Justice, are you still with us?
yes, it looks as if they may.
I am with you, JP. It's just that the screen wasn't showing anymore.
Okay, thank you, Chief Justice. Sorry about that.
Thank you. So I don't think my age objectively is a factor of any great importance.
How many more years do you still have to?
I have 5 years of service left, and I'll be here regardless. So that's the age issue. I was going to say that I think you'll find that people in my generation carry on well into their 80s. And so if there's anyone here on the commission who can ride a bicycle over a 100-kilometer route in 3.5 hours, I invite you to join me, and we'll see who gets the orange first. As to the other question regarding the fact that I'm a white man, I do understand, as the Constitution prescribes, that the racial composition of the bench is something that needs to be weighed, and it's by no means the least important consideration. What of course I do not know is what policies or guidelines the JSC has set up in order to gauge how that balance is to be done. As far as I'm aware of the deputy judge president's posts in the country, there's only one white person in that office. Is that a consideration? It's not my role here to argue that point, but obviously that may well be the position. As far as the judicial leadership as a whole is concerned, if that too is to reflect the racial diversity and gender diversity of the country, then presumably there is space for white people in that capacity. I appreciate that there is huge sensitivity about the racial identity, more especially of those who do serve in the leadership of the judiciary.
Yeah. Okay. One last question, Chief Justice. I'm sorry, I've taken long, but this is the last one. You started acting after colleagues who were senior to you had had their opportunities to act. And in that process, 2 women who were senior to you also acted. Is that correct?
That is correct, yes.
As DJP, is that correct?
Yes. Yes.
Thank you very much, Chief Justice. I've got no further questions.
Thank you, Judge President. Honorable MEC.
Thank you so much, Chief Justice. Good morning, Judge Sutherland.
Good morning.
Are you well this morning?
Excellent, thank you.
Thank you so much. It's quite clear that your court case management skills stands out as the key thing that we can get if we have to recommend your appointment. I'm very keen to understand how will you ensure that there will be a skills transfer to those that will be working with you if you are a successful candidate, and how will those skills be transferred? Thanks.
Yes. Well, there are 2 dimensions to that. The one is more generally across the bench as a whole. To what extent does one use one's leadership role to see that newer judges absorb knowledge and skills and have proper exposure to that? And the other dimension, of course, is who would succeed me. Both of those matters I'm fully aware of, and I think it's appropriate that it be so. I have been lucky to get along with all of my colleagues. Indeed, the Johannesburg bench is a very happy place. And the personal interaction helps enormously in that respect to engage newcomers and to make them feel comfortable. And also, insofar as it is in the realm of the DJP, to assign work and to direct who should sit in what court and so forth, one can systematically make sure that newcomers get the proper exposure so that they don't find themselves in a stagnant situation. It is always a danger. Happily, on a big bench, as we are 38 judges in Johannesburg, there's always room to do that fairly successfully. As far as a success is concerned, that of course is not something that lies entirely in my hands. With the JP and with the other deputy judge president in the division, it's incumbent on us to identify people who ought to be groomed and to see to it that they get the appropriate exposure. One of the things that is to be used to great advantage in Johannesburg and in Pretoria is the system of committees which are enrolled to advise the deputy judge presidents and the judge president. As you'll have seen, I sit on several of those committees, and one of the ways to orientate newcomers is to draw them into the various committees so that they can get involved in policy development. One of the really big important issues in terms of grooming someone for leadership is to have some role in policy formulation, to get involved in the systems and understand what, so to speak, the back office does. One of the least appreciated aspects of court administration is paradoxically the registry. The support staff tend to live in the shadow of the judges, and their critical ability to perform and to deliver what the judges need in order to give it an efficient service is something I'm very conscious of. So the answer to your question, MEC, is that there's certainly opportunities to do exactly that. I'm conscious of them, and that is what I will do.
Thank you so much, Chief Justice. I'm fine. Thanks.
Thank you, Honorable MEC. Honorable Minister.
Thank you, CJ, and good morning, Judge
Good
Sutherland.
morning, Minister.
Thank you. How do you put this issue of age to say that it is an old, it's old-fashioned, when old white males have always been privileged in this country?
Well, I don't deny that my white skin has allowed me to be free from oppression. But the extent to which privilege explains why I'm here is a little more complicated. I didn't grow up in an affluent family. I had no prospects of a university education. My parents had no money. The reason why I found myself in the civil service straight after school, because I took advantage of a bursary in order to educate myself. And I and my brothers are the first members of my family ever to see the inside of a university. So I'm not an example of someone who was born with a silver spoon in his mouth. I got here on my own. And I'm conscious of the fact that because I have been white, I have had certain advantages given to me under apartheid. What I am proud to say is that I have never served the apartheid project. I have throughout my life been in opposition to it vocally, as a boy, as a man, as a professional. And if anyone thought that the investment which the apartheid state made in my education was going to accrue to its benefit, they have been sorely disappointed. I appreciate that in the context of transformation more broadly, one needs to create spaces. But there's, of course, the danger of getting bogged down in the way we perceive one another. I fully understand that there may well be many people who look at me and all they can see is yet another white man, and that may be the end of their perspective. I simply ask that perhaps when you look at me, you can see a fellow South African who is concerned to be part of the nation-building project and to produce a community in which we can all have reciprocal respect and achieve social cohesion. If you can see that in me, then I shall be grateful. And as I come here as a volunteer for public service, take me as that.
Yeah, I've heard your role in the management of cases and files. What has been your role in the digitization process for the Gauteng division, and what do you think will be your appointment will enhance that?
Yes. Well, I'm fully aware of the ongoing project in that regard, and of course it has several dimensions. You speak of digitization. We have already in Gauteng got the case lines program, which I can go into detail a little later if that's necessary. That has been a godsend to us for COVID and is undoubtedly the way forward into a paperless future. There are steps at the moment being taken to digitize existing hard copy records going back. That's in its infancy, but is absolutely critical. When we speak this morning, the day after the University of Cape Town's library is burning, there can be no more urgent project than to safeguard the records in state departments. As a result of various reasons, the state of our archives is in urgent need of rescuing. It's not safe, and digitization can't come fast enough. Then, of course, e-filing is around the corner, which is going to revolutionize attorneys' litigation practices. And over the next 5 years, which would be the time that I would be serving as Deputy Judge President, some of the principal projects which need to be driven is the further expansion of e-filing, case lines, digitization, and of course, as we have learned during COVID, the fully implemented utilization of video link opportunities in order to create efficiency and save enormous costs. So that's the task ahead. And I relish the opportunity to be part of that.
Thank you, CJ, and thank you, Judge.
Thank you, Minister.
Thank you, Minister. Honorable Magwanisha.
Thank you, CJ. Good morning, Judge Sutherland.
Good morning.
Yes, my first question was asked by already, it has already been asked by the MEC. So I will focus on my last question, which is more focusing on you as a senior counsel, when you're a senior counsel. How many Black advocates, let's say name 5 Black advocates and 5 women advocates that you empowered as a senior counsel?
I made a report on that when I was interviewed initially in 2012. And the position was that I had done a check on my records. And during the time I was silk, running up to the time I was appointed as a judge, something over half of the juniors that I led were Black and women. And what perhaps is equally important is that approximately half of the attorneys who briefed me regularly were Black, either from Black firms or in what would generally be thought of as the big white firms, partners or associates in that. So I took the view then that my practice was reasonably well transformed. The issue of what I did in order to promote and advance black colleagues didn't only stop in the actual fee generating work I did as an advocate. I was a leader in the bar, and I was the leader of my group. And in both those capacities, I did several things. But let me give you just two examples. When I became leader of my group, the Bridge Group, in 1999, I took charge personally of the recruitment of pupils into our group in order to ensure that we would have an appropriate racial mix of pupils. There were already black members in the group, and indeed from the time I joined the group in 1978, there had been black members in that group, even when there were only 3 black members in the whole of the Johannesburg bar. So we were a group that had forward-thinking ethos, and each year I would go and select a number of pupils that would advance transformation objectives, bring them into the group, assign them to pupil masters, as we would call them then. I also innovated the pupillage system by assigning a silk to each of them, so they had 2 mentors. I always took a mentor myself, and in every case, I always took a young black pupil who I could advance. And then, of course, after pupillage, the big question at the bar especially is what happens then? And at my initiative, we introduced a scheme which we called the Junior Associate Scheme, in which we would accommodate principally our pupils, but sometimes we could take pupils from other groups as well, to have subsidized accommodation, reduced fees, so that for the first 2 years, they would have chamber accommodation at a cheap rate, group fees at a cheap rate, and would have proximity to a group of successful practitioners who could draw them into matters. And in that way, an enormous number of young people came through our group and into practice, many of whom practice successfully today. The other example I want to give of promoting transformation by promoting individuals is the scheme which my group initiated at 2 levels. The one was with the Wits Legal Aid Clinic. Access to justice has always been a problematical issue. And my experience of that over many years is that indigent people really only get help when some form of NGO can be present to intervene. It's not good enough just to have procedures at the level of the court. What we did was we went into a partnership with the Wits Legal Aid Clinic. They would send us matters which we would assign to juniors with a silk mentor, and that would enable the youngsters who at that stage would have had no experience and no reputation to be seen in court doing a credible job. My mantra in all the lectures I give to young advocates is that the most important thing in order to develop your market credibility is to be seen doing credible work. And over the years, that scheme flourishes now. Hundreds of briefs are sent to my group, which are distributed amongst the youngsters, who have all the assistance from the more senior practitioners, and they are in court, being seen to do the work, and at the same time, of course, we're meeting the Wits Legal Aid Clinic mandate, which is to actually realize, in practical terms, access to justice. So those are some of the things that I was involved in actively as an advocate, both in my own practice and as a leader.
Thank you, Chief Justice. Thank you, Judge Sutherland.
Thank you, Honorable Magwaneshe. Honorable Moima.
Thank you, Chief Justice. Good morning.
Good morning.
Judge Sutherland. Is my understanding correct from your judgment in Amabungani, which is one of your latest judgment that was confirmed, I believe, by the Concord?
Yes.
Is my understanding correct to say that bulk surveillance continues to the extent that it put law enforcement agencies in a better position to fight crime, but to the extent that there is no notification when it interferes with the attorney-client relationship and also with the media freedom, it is unconstitutional. And to the extent that bulk surveillance beyond South African borders, it is allowed. Is my understanding correct?
My understanding of what the Constitutional Court confirmed is that bulk surveillance is unlawful because there is no law which permits it. There may well be a law that is in due course passed to permit it, with or without conditions. But it goes no further than that. It needs a lawful sanction in order to be used under the principle of legality, which provides, as we know, that no public power can be exercised without an authorizing source. So that was the difficulty in that case with the bulk surveillance. There simply was no warrant to do so. There was a debate about other countries doing it as a matter of course. How could we do without it? Perfectly valid consideration. But if Parliament considers it appropriate, it will doubtless pass a law. And if that law is consistent with the Constitution, then it shall stand. But that's the state of the law on that score at the moment.
Thank you, Judge Sutherland. Thank you, Chief Justice.
Thank you, Honorable Moimang. Advocate Mpofwesi.
Thank you very much. Good morning, Judge Sutherland.
Commissioner Mpofo, good morning.
Good morning, thanks. I just want to give you a word of advice. That seat you are sitting on now is not a place for modesty. That's where you are allowed to brag as much as you can. I just wanted to talk about the issues that the JP was talking about. Now, I have had experience with you for many, many years, particularly in the area of the rules, the rules committee of the GCB. And I wanted you to just link that, because in terms of your experience in crafting rules, as I think it was either you or the JP, for the people who are not lawyers, it's very, the issue of procedure might be seen as a subsidiary issue, but actually for a court situation is crucial. I mean, in substantive law, you might know that if you do a contract, if you sign it and so on, that's all very important too. But from a court setting, the procedural rules are more crucial and may affect access to justice. Now, to what extent has your very extensive experience being involved with rulemaking, procedural rulemaking, contributed to the things that the JP has highlighted as your contributions, and even where you have volunteered to do things without necessarily having the title to do so? And in that answer, if you can at least try and emphasize how important the procedural aspects and the management of a court setting is vis-a-vis the actual outcome and cross-examination and all those things.
Yes, yes. Certainly. Thank you for the question. The point of departure is that the work of any division in the judiciary can only take place through appropriate systems. And one of the issues which bedevils Gauteng is the huge bulk of work which there is. Even with 38 judges in each seat, it is a strain to keep up with the demands. I recently extracted some data. The number of trial matters, that is to say, summonses which were issued in the last 6 months of 2019 compared to the last 6 months of 2020, increased by 26%. And regrettably, data available at my court for earlier periods is not available. I'm told by the registrar that it's kept by the Department of Justice and they don't have access, which surprised me. The reason I mentioned this early in my answer is that in order to have appropriate systems, you need to have the right management data so that your systems can produce efficient, expeditious, and appropriately organized work. And so the directives which I've been involved in drafting rules for are designed in order to create an efficient throughput. We need to know what's coming in, we need to know what is our available resources, and we need to have an objective to get through that work in a certain time. So without systems and without adapting systems to changing circumstances, whether it's volume or the complexion of the work, as the case may be, one gets stuck in a rut, and that's when you start having lead times of 18 months or 2 years between wanting to go to court and getting there. So systems are significant, and in order to have the appropriate ones, one needs to be alert to what's going on the ground. And I've endeavored both formally and informally to revise and introduce, where there were none, systems which will inform the leadership of the division as to how to make those adaptations. And that's an ongoing business. At this very moment, I'm in conversation with the registrars dealing with the motion roll. The lead time on that is unacceptably long. And we're exploring whether or not there are some simplifications we can introduce in order to accelerate that. But the ultimate point is one's attitude towards the management of the affair. And I've endeavored to engage all the players who are involved, both within the registry and in the judicial leadership, in order to produce an efficient system that will meet the demands of the litigating public.
Thank you very much, Judge Sutherland. The other issue, which if the Chief Justice will give me some space to deal with this.
Go ahead, sir.
Thank you, CJ. You've been asked correctly in the context of South Africa about the fact that you are a white male. And my question, which will come at the end of what I'm going to say, relates to the extent to which the issue of pigmentation, mere pigmentation, should guide us when we deal with this question. And don't get me wrong, pigmentation is important because that was the criterion that was used to advantage white people, of whatever. Even a white hobo was still superior than a black professor. So pigmentation is important. But the issue is, somebody like you, I mean, from my own personal experience, I know you as a young junior in the 80s, who was one of the few people who were prepared to assist us in defending cases of MK soldiers when it was not popular to do so, even at the bar. And as you put it, to that extent, you were a disappointment to the apartheid system. And I'm sure you were a disappointment to many of your colleagues as well. And I want you to tap into that kind of experience as far as transformation, which goes beyond gender and pigmentation. Whether we don't need transformation of ideas, of people who were able to fight against the odds in a hostile system. And as you know, I was an article clerk to Kathy Setchwell at that time, who defended those cases and who briefed you. And she was even a bigger quote unquote disappointment because she was a woman, lefty, lesbian, and all the things that apartheid would have regarded as being a disappointment. But in my book, she's probably the greatest lawyer I've ever met in my entire life. So to what extent should we, yes, look at the bean counting and making sure that the numbers balance, but also to what extent do we need diversity of character and ideas, which goes beyond the skin color?
I dare say the place to begin is what sort of dream one has about where we're going. It is sometimes dangerous to subordinate your planning to too much blueprinting. Sometimes the best you can do is simply have a direction of travel and keep seeking opportunities to advance it in that direction. But one of the most fundamental problems we have at societal level, never mind at the level of the profession or the judiciary, is mindset. Without mindset, we achieve nothing. One of the great disappointments I think many of us have is that at this stage, a quarter of a century after democracy, there is no national solidarity that bridges all the segmentation that went as a matter of course in the era of apartheid. That's a project on which those who want to build social cohesion and a community that is not dictated by interracial animosity need to keep going. I'd like to think that that's been the organizing principle of my life. And what I think is important in developing mindset is for people to exhibit their mindset publicly. To take an example which is perhaps even more acute now than ever, given over the past recent months, the issue of the place of women in society. We can pass laws, we can have efficient gender-based violence courts, we can do all these responsive things. But as long as women are regarded as a commodity, there can be no real long-term practice. And one of the greatest evils of our time is the commodification of women. Be it that they're a precious commodity or a commodity to be adored, it doesn't matter. As long as they're a commodity, they will be inherently subordinated. We have to get past that. That's something we need to be appreciative of in order to tackle it. And so mindset is critical. One needs to marshal one's friends around those projects and bring everybody else along with it.
Thank you very much. Thank you, CJ. I'm sorry, just to follow up on my earlier question. I don't know if you did address it, the connection between the rulemaking and access to justice in your answer.
Well, let me deal with that. I'm sorry if I didn't include that in my answer. If the purpose of the courts is to afford genuine access to justice, then the systems which we use must be susceptible to achieving that objective. It can't just rely on goodwill. There must be a structure within which people who seek that can achieve that. And so the opportunity to recognize the needs for fulfilling those objectives need to be inherent in the system that you choose. If we think about, on the one hand, structural changes which were introduced under the Labour Relations Act to create the CCMA, which is a crucial device in granting effective access to justice in that context. We don't have a corresponding institution in litigation generally. And that's why, as a matter of practice, there's no particular reason why it has to be that way, but certainly the South African experience has been that in the general litigation sphere, where rights and access to justice need to be advanced, NGOs have played an incredibly important role in making those things happen. The AIDS campaign is perhaps the most signal example of that. And that's why those who make the systems and write the rules have to be conscious of those considerations, because it must be catered for and to facilitate the opportunity to do so.
Thank you very much. Thank you, Sir. Sorry for the extra question.
No, it was necessary. Thank you, sir. Commissioner Tsepe.
Thank you, CJ. Good morning, Judge
Good morning
Sutherland.
to you.
I have two questions for you, Judge Sutherland. The first one is still about the work you have done, particularly regarding ethical conduct of practitioners and of the judiciary from the redrafting of the ethical codes while you were in the GCB. Could you tell us a little bit more about that role and what you continue to do there? And I'm looking at it as an important role in achieving the objective of an independent and impartial judiciary as a cornerstone to a democratic society and the rule of law. Could you speak a little bit more about that, your job, your role in that regard? Thank you.
Yes, thank you. At the time that I left the bar to come to the bench, I was the then principal lecturer in ethics to the Johannesburg pupils in their pupillage program. And triggered really by my hands-on involvement in that work, I became particularly interested in the normative foundations for the professional ethical code. And I recognized in working through what was then the Red Book, how antiquated it was. And so I offered the chairman of the General Council of the Bar at the time to lead a team to redraft the bar's ethical rules, bring it up to date, and to get rid of some of the archaisms and so forth. And I ended up doing a draft to rewrite, principally aimed at the advocate's profession. That text which I drafted is now substantially 3 of the chapters in the Legal Practice Council's Code of Good Conduct for Practitioners. And what I was able to do was to, if we start at the little things, I managed to do the entire draft in a totally gender-neutral fashion. When you find text in the LPC's code that's not gender-neutral, that wasn't mine. And it was with an eye on those considerations that a lot of inappropriate rules were jettisoned. And largely speaking, what the LPC has approved has gone along with that. But in addition to that, I've been active in giving lectures on ethics to the profession. This Friday, I'm giving a lecture to the pupils of Babasa in their pupillage program. I've given lectures to various groups at the bar and to the attorney's profession on ethics. And I continue to do research on that and research on judicial ethics. I'm busy preparing an article on judicial ethics for publication in Sajay's journal in the next edition. So I've developed a particular interest in that dimension, both in the legal professional ethical norms and in judicial ethical norms. And I hope to devote time as it becomes available to pursuing that objective.
Thank you, Judge. My second question relates to acting judges, and it's
Chief Justice, I beg your indulgence. Before she asks the second question, I would love to follow up on this question of ethics, if you allow me to do so.
Please go ahead, sir.
Okay, thank you very much. Good morning, Justice.
Good morning, Commissioner.
Okay. How unethical is the judiciary today, in your view?
Well, there are issues about which we ought to feel unhappy. And to the best of my knowledge, they're being addressed. We're not always entirely satisfied that they're being addressed fast enough. But it would be invidious for me to make comments on any of the particular individual issues which the Judicial Service Commission have to deal with. But if your question goes deeper than that, and you're asking for my perspective of whether, on the whole, the judiciary is ethically trustworthy, I have no hesitation in saying that it is. Aspects of what are allegedly or are indeed unethical are aberrations. And the country is fully entitled to be confident that the bench as a whole is ethically strong.
Okay, you, in your acting stint, you manage judges, part of what you're doing. Do you think, in your view, some judges are corrupt or they can be corrupted?
I've never met a judge who I had any reason to believe was corrupt. Of course, judges have different views on different things, and we don't always, for example, agree with the laws that exist. Sometimes we think they're not strong enough, sometimes we think they're weak enough. Often laws which we recognize are well-intentioned somehow fall short of our own ethical standards. So judges do often have to grapple with rules and laws that don't sit well with their own ethical predisposition. But to suggest that one has an expectation that there's a danger of coming up before a corrupt judge, I think would be a gross exaggeration.
Lastly, linked to that, CJ, what is your view about the current, call it a perception or an allegations that some judges are corrupt? What is your view on that?
Well, it's disappointing that the allegation is made. On the information available to me, it's an empty allegation that is yet to be substantiated. It's certainly open to anyone in the world to criticize the judiciary, and I subscribe to the view that the judiciary should be resilient to criticism. But if you want to say that Judge Sutherland is corrupt, then the least you do is to say why. The nation expects judges to be ethical, and if someone has a genuine basis for saying that a particular judge is not ethical, then one must come up and say exactly what it is so it can be dealt with. The Judicial Service Commission itself comes in for quite a beating from time to time. But it cannot function without facts. And it doesn't know the facts unless someone who claims to know them reveals them. And that's really where we are on those particular claims at the moment. It's very unfortunate that those who make those claims do so in such a damaging way.
It's okay. Thank you, CJ. I've even forgotten my opportunity to ask my question. Thanks.
Thank you.
Thank you, Honorable Dodovu. Honorable Nyambi?
Chair, I still had my second question when
Oh,
I
I'm
was-
sorry.
Thank you. Thank you, CJ.
Over to you, over to you, Commissioner Tsepa. I apologize.
Thank you, CJ. I appreciate it. Judge Sutherland, my question, as I said, my second question relates to acting judges, particularly in your divisions. In your experience, while you were acting as the DJP in the last 3 stints, do you think your division has systems in place to support acting judges, particularly in running of matters, judgment, writing, and just in appropriate allocation of matters to ensure that there is adequate exposure? And if not, what do you intend to do were you to be appointed in order to deal with that? Thank you.
Yes. Well, the short answer is I would have to do a survey of acting judges in order to determine what the current cohort of acting judges think about the extent to which they're properly and effectively integrated. But I can say that it's certainly a point that the leadership is conscious of, and the endeavor to give judges proper exposure during their time as an acting judge is in fact very important for reasons which are not necessarily aimed at the judge's self-interest. When one's looking at a pool of acting judges from which to encourage some or others to take a permanent appointment, it's self-defeating if you haven't given those individuals an opportunity to do various things. So in the institution's self-interest, there is a studied approach to giving that access. Often, just to take a concrete example, if a senior silk at the bar, for example, is an acting judge, and it is well known that that person has had a varied and broad experience, one can be comfortable that there is no specific intervention that's needed at that stage. But if you have a candidate who has had less litigation experience, or whose principal credentials in practice have not been litigation, then it's incumbent upon one to know that, recognize that, and give that person an opportunity to be exposed to the various types of work. One of the ways in which that can be done, of course, is to put them on full benches or full courts, so they sit with other judges and do it. And of course, even when, for example, one is sitting as an acting judge with 3 other judges in the unopposed motion court, there's an opportunity to discuss with other judges doing similar matters on the following day what should happen and what should not. One of the unhappy consequences of the complexity of the work which we do is that it's unlikely that any acting judge, when arriving, will have had exposure to everything. They need to be inducted in the directives. They need to be shown the ropes around certain logistical things. And if I take a substantive example, in dealing with foreclosure matters, as a result of Gudwana and also of JAFTA in regard to eviction matters, the complexity of our procedure for ensuring that Section 26 of the Constitution, the right to housing, is is properly met is now very, very complicated. And if you haven't done foreclosure work in your practice when you come as an acting judge, you need to bone up on all of that. And we're very conscious of the fact that we need to do that. So in summary, we're very lucky in Gauteng is because we've got the largest concentration of practitioners in the country. And whether we're recruiting more generally, we've also got the largest concentration of women practitioners in the country. So in a sense, relatively speaking, we're spoiled for choice. And in seeking to produce a bench that meets all the requirements of the Constitution and our functional needs, we're always on the lookout to induct people appropriately so that if we do pick them, it's not a guess, there's a rational basis for grooming someone for a permanent appointment.
Thank you, Judge. Thank you, Chief Justice.
Thank you very much, Commissioner Tsepa.
CJ, I'm asking to be put on the list. Sigogo.
Oh, okay, sir. Okay. Honorable Nyambi?
CJ?
Yes. Yes,
Can you also
JP?
put me on the list?
Thank you. Honorable Nyambi?
Thank you, CJ. Morning,
Yes,
Judge.
good morning.
Commissioner Mpofu and the ministers covered the first question, so I'll ask you just one question. As we have quite correctly in terms of your CV indicated that you never served as an apartheid project. You have got serious experience. I can see that as early as that historic year of 1976, that is very significant in our country. You were a regional court prosecutor. So if you can be able to take us through in terms of that experience and how that experience is assisting you today in your current position, and concluding by giving the immediate current challenges facing judiciary in our country as somebody applying for this leadership position.
Yes. Well, let me deal with that step by step. My time as a prosecutor in the district and the regional courts I dealt with the usual range of crime. When I was on the staff of the Attorney General, I was prosecuting in murder, rape, and robbery matters. And that, of course, is a very valuable experience technocratically in that you're in court every day. One gets an enormous amount of experience in that. And so one becomes familiar with the courtroom dynamics. And later on, when one's a more senior practitioner, one's aware of what one learnt at that early stage. And you're looking to see whether those who you are mentoring have the similar opportunity to develop those skills. If I think of an ideal apprenticeship for the bench to become a judge, it would be an individual who has the opportunity to serve in many different capacities, as attorney, as a prosecutor, as a counsel, both as a defense counsel and doing civil work on both sides of any particular issue. And that's what I certainly encourage youngsters who are thinking of going into the profession to do so. The idea of having a generalist foundation is of enormous benefit to anybody who is going to become a judge. Because as a judge, you are going to have something of everything. And although we talk about experience in a somewhat glorified way, experience is simply familiarity with something and having had a chance to actually practice it. So that's the critical thing that needs to be done. What one's alive to as the judiciary, our greatest challenges really are meeting the demands of the litigating public. We need to have cases heard earlier than later. We need to be able to write judgments that are convincing. We need to get our judgments out on time. We need to be alive to the dynamics of our society and be aware of the context in which decisions have to be made. We need to be socially aware. And SAJE, apart from other informal initiatives, is one of the devices which is mobilized in order to give us perspective in those regards. But if I can piggyback on an answer I gave a little earlier on, it all begins with mindset and what the mindset of the leadership is. If the leadership is aware of issues, it can drive programs in order to achieve desired aspirations. So if I go back to my own personal experience, I was very lucky to have a well-rounded apprenticeship, and appreciative of that, I seek to promote opportunities for my colleagues who come after me to enjoy the same opportunities.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Honorable Nyambi. Prof.
Thank you, Chief Justice. I'm covered. Good morning.
Good morning.
I'm not going to ask you any questions. You've answered all that I wanted to hear.
Thank you.
Just one question from me, CJ Sutherland.
Is there a follow-up, Honorable Claver?
No, please add me to.
Okay, thank you, sir. Thank you. Commissioner Barnard?
Chief Justice, thank you. I too am covered. Thank you.
Thank you very much. Commissioner Sigogo?
Thank you, CJ.
Yes,
good morning, Judge. How are you?
Good morning. Thank you.
It is quite concerning to me that in a big division like Gauteng, particularly Johannesburg, we have only one candidate for this position. Then my question is, as an acting DJP, have you identified black judges, particularly women, who should be given opportunity to act in that position in order for them to acquire necessary experience to be considered in the future? And if you have done so, have you communicated your same with the JP?
Well, strictly speaking, of course, it's the JP who would be in a position to be making those selection decisions. As you presumably know, the immediate predecessor to the acting deputy judge president's post was Judge Carlse. She did not wish to make herself available for this position, as she preferred to seek an appointment to the Supreme Court of Appeal, which in fact has now taken place. Judge Victor has acted. As regards the other women judges on the bench, my own personal view is that there certainly are those who already demonstrate the right interest in the organizational dimension of the work that could be groomed to be Deputy Judge President in due course. So I'm alive to that. I can't really offer you, from my vantage point, a better example, a better explanation of why, among all of my colleagues, I'm the only candidate here. It's not really for me to say. One might assume that some were not interested, others were not interested now, it may become later. All of those are imponderables. But that's about as far as I can really take that.
CJ, just a quick follow-up.
Let me just establish whether Commissioner Sigogo is done.
Yes, I'm
Commissioner, have
sorry.
you finished?
Chief Justice, I have another question which is not related to this one. Maybe a Commissioner Mpofu can take a follow-up.
Let me just make sure I don't forget that you still have a question. Over to you, Commissioner Mpofu.
Thank you, CJ. No, my intervention won't be as long as that of the Dovu until you forget the second question. No, I just wanted to come back to this question of why you're the only candidate. You've put some possibilities which might be that other people are not interested and so on. But isn't it the fact that the other reason could be that the people who might have thought about it support your candidature?
That is so. Certainly, I've been gratified by a number of express support messages which I've received. And I would hope that if you do approve me, that would be welcomed by my colleagues.
Thank you, CJ.
CJ, Cyril Xaba, because my question relates to this, may I take a follow-up at this stage?
Please proceed, Honorable Xaba.
Thanks, Judge. See, you bring in excess of 32 years of experience as a jurist to this position. And I also contrast it with the fact that you are the only candidate for this position. Must I construe it as a deference to your seniority? I just want to understand the pecking order in the division. Thanks.
I don't think that deference to my seniority is a factor at all. I'm glad to say that the community of judges in Johannesburg is very egalitarian. There's no bowing and scraping amongst us. And so if it is so that any one or more of my colleagues supports me, I rather doubt it's simply on grounds of seniority.
Thank you, Judge. Thank you, CJ.
Thank you, sir. Commissioner Sigogo, back to you, sir.
Thank you, CJ. Judge, my next question is in respect to the phantom cases that you referred to when you were responding to the JP. In your response, you indicated that about 95% of cases will not proceed on trial, and in a way it could amount to inherent abuse of system and for practitioners to drive this. My understanding of this phenomenon relates mainly to the cases of the road accident fund. And it has been, I'm not sure, but I believe you are aware that at a certain point, the road accident fund had taken a policy decision not to settle matters before they were allocated trial dates. And if that was the case, were the practitioners left with any alternative other than to get trial dates if their matters were not being settled by the RAF before they got trial date?
I'm not aware that the Road Accident Fund has said that out loud, but I am aware that it is the perspective of many litigation attorneys that was the case, and that a great deal of the difficulties in Road Accident Fund litigation has got to do with the internal administrative difficulties which that institution suffers from, and its lack of money. Hence the radical decision last year for it to dispose of its entire panel of attorneys. So my remark about abuse of the system is not directed at the inherent dynamics of road accident fund litigation, where attorneys obviously have to respond to the defendant's stance in regard to claims, but rather to a very commonplace experience which is now becoming less common. And that is a matter is eminently settleable months before the trial, but it is left on the roll for no perceptible reason other than to be able to claim a trial fee. In our new system, the room for such abuse is much diminished, if not entirely eliminated, because there is an opportunity to hive off matters which have a prospect of settlement in another channel. And ultimately, the reason we can now have a trial roll of 16 matters and meet all demands for trials on such a number, as opposed to the absolutely nonsensical figure of 120, is that matters do go off somewhere else to settle. Or, if they're not ready, they don't take up space on the trial roll and then extend the lead time. So, from a litigation attorney's point of view, there are huge advantages. One of the great difficulties that inhibited RAF litigation previously was if you had a long lead time, by the time you got to court a year or 2 years after you'd sought a date, your medical expert reports are out of date. You may need an update. So those situations frequently provoked postponements. When your lead time is only 3 or 4 months, there's no danger of that. So we've not been insensitive to litigation attorneys' requirements, and certainly they are consulted in regard to what we want to do. And to contextualize this in answers I've given to other questions, the system which we have and the system which we ought to persist with is one that meets the needs of the litigating public. And I think we've managed to achieve that. It will require adaptation as we go along. It's not going to be something static.
Thank you, CJ. Thank you, Judge.
Thank you so much. Honorable JP Leo.
Good morning, Judge.
Thank you, Chief Justice. My question, good morning, Chief Justice, and good morning, Judge.
Good morning,
Chief Justice, question related to the acting people who acted in that position since the vacancy of that post, and I think I'm covered by the other commissioners.
Judge Sutherland, just one question. Are you aware that your court shoulders the responsibility to run a pilot project on court-annexed mediation, coupled with aspects of judicial case management? Win-win court-annexed mediation coupled with judicial case management, and that there was a report prepared by both deputy judges presidents that was presented to me. Some workshopping happened. Are you aware of that?
Yes, I'm fully informed about that.
Yes, carry on, sir.
Judge Collipin and I have had a discussion in his role on the Law Reform Commission. He's briefed me on the fact that there's a bill in progress to expand the use of mediation in high court litigation. And I look forward to seeing what that has to say.
And has your court already begun to implement, following the training program or workshop that was run in Gauteng by a colleague from the US who was assigned that responsibility?
Yes. Yes, some of our judges went on that course, and we have transmitted the information which was gleaned in that course to fellow colleagues. Our intention to pursue mediation training was halted by the COVID, and that of course has interrupted many things amongst that. But in more recent times, Judge Keatley and I, Judge Keatley being one of the judges who went to Utah, have been in conversation about what we can do in order to promote that. One of the things that, for example, was interrupted by the COVID was a embryonic project involving family law practitioners in Gauteng in order to streamline our systems to accommodate the particular problems that take place there. And obviously a realm where mediation would be as important as anywhere else. But for the moment, things are embryonic, and we do not have any programs in place at this time. It's work for the future.
Thank you very much, Judge Sutherland. You are excused, sir.
Thank you very much. And thank you very much, Commissioners.